Hi everyone, and welcome back to the channel. Tony here with Italian Dual Citizenship Assistance. And in today's video, I'm excited to bring you part 2 of my interview with top Italian attorney Arturo Grasso. Now, if you haven't seen part 1 yet, I would suggest that you follow the link in the description, go back to that first video, and then come back for this one. Now, in today's video, we're going to be taking a look at the Italian Supreme Court's likely upcoming review of the minor issue rule that has blocked so many people since the October 3rd, 2024 circular. Now, for those of you who are not familiar with this term, a very simplified explanation is that the minor issue refers to a change in legal interpretation that changed the requirement from simply that an Italian parent needed to maintain their Italian citizenship, meaning they didn't naturalize as a citizen of a country outside of Italy until after their child was born, to now the Italian parent must maintain their Italian citizenship all the way up until the point that their child reaches adulthood, or both the parent and the child are considered to have lost their Italian citizenship at that point. Now, as you'll hear in the interview, according to Mr. Grasso, it looks like we have a lot to be optimistic about with regard to the minor issue. Now, we'll also be talking about 1948 cases, where they stand currently, and what the future likely holds for these type of cases. And a quick reminder that I do offer affordable 20, 30, and 60-minute consultations for anyone who would like help understanding their eligibility, options, or best path forward toward becoming an Italian citizen by descent. And you can book your one-on-one consultation with me at italiandual.com, and the link is in the description. I hope you enjoy part 2 of my interview with Arturo Grasso.
In our last interview, you mentioned you predicted a number of things. You said that there was going to be this constitutional court referral, and you mentioned some of the courts that were looking at referring to the constitutional court. And sure enough, right after that, we had the referral in Turin. You mentioned that you felt that the minor issue was something was happening, something was brewing, and that there was going to be a change there. And now, flash forward a little bit, we're seeing this decision in the Supreme Court to take a look at it. And I don't know if that's specifically what you were referring to, or if you had even other aspects or things that you were referring to when you mentioned a possible change to the minor issue. But this minor issue has been a huge block for so many people. I'd love to hear your thoughts on the minor issue and the Supreme Court's examination of it.
Yeah, it blocked a lot of people. And so many people blocked with this minor case. Again, there are signals. Like with the court, I can only predict something which is based on experience and between the lines, what I've read from a legal perspective. We had a case heard in the chamber before the Supreme Court, the Court of Cassazione, which is the third level. It's not really a Supreme Court like in the US. The Supreme Court in the US is more like a constitutional court. Ours is the third level of justice. The Court of Cassation only looks at if the laws have been applied, not at the merits. Doesn't care about the merits, just if law were applied properly. So that's why we are before the Court of Cassazione, because whether a law, Article 12, should apply rather than Article 7, attorneys say Article 7, judges in Rome, especially in Rome, said Article 12. What happened was the first signal was in January this year, 2025. We had an chamber hearing before the Court of Cassation in Rome for a minor case, and the judge held the case at the chamber, and we were expecting a decision, but all of a sudden, rather than a decision, they said, oh, we are reconsidering the approach, and we will go back and to have a public hearing on this. That was so strange, because once you have a chamber hearing, why you should go back and put the file back on the docket to set a public hearing for this? I understood that later. Why was that? Because in April, there were 3 cases before the Court of Cassation with leading attorneys, and they were discussing publicly for the first time during the hearing about a minor case before in a public hearing. And what was the surprise was that the public prosecutor changed the approach. So it was a real big surprise because the prosecutor spoke during the hearing and said, it has been a long debate. We've been thinking carefully about this. We have reconsidered the case and we do not agree with the state attorney, because in the same hearing, you got the judges, the public prosecutor, the state attorney on behalf, the defense for the ministry, and the defense for the petitioners, the applicant's representative. And the public prosecutor said, we change approach and we agree with the attorney, because they made a wide discussion. It was basically what we've been writing, that Article 7 is a special provision, is not, the Article 12 is a general provision for those who have only one citizenship most of the time. They're not dual, they have no birthplace citizenship, and that they got citizenship, derivative citizenship, because of the change of the father or of the parents, father, mother. In the minor case, as with birthplace citizenship countries like US, that does not happen. So when the parents naturalize, they not give a child, do not derive any citizenship because they already got a birth. This is the main principle. But what the prosecutor said, it wasn't a conservative approach from Italy, losing all this child, lose all this community abroad. So it wasn't a conservative approach trying to keep Italian citizenship among people moving, immigrating abroad. And especially in the birthplace citizenship country, that was the principle. And it has been the principle forever, for so many years. So today, consulate or commune are asking people, oh, show me that your ancestor did not lose their citizenship or wanted to regain their citizenship. Would you consider someone going to the consulate regaining citizenship, or not, children trying to get citizenship back? The consulate would say, hey, that's not the law. The law says that you were born already when your father lost your citizenship, so you can't ask that. They would have been dismissed by the consulate. And today, they joined the same approach and asking for such a document. When you go to the consulate, they're dismissing all the minor cases consulate by saying, give me evidence that the child regained citizenship, came to the consulate and make a formal declaration to get citizenship back. It simply doesn't exist, because they would never accept something like that. But anyway, what changes now? Because of these changes in April, later on, Meloni had another 2 hearings, and he got an order by the court saying, we deferring this case to the prime president of this section, which was the first section, in order for her to defer it to the United Section. So it's still upon the prime president of the section number 1 to defer, but this is going to happen. I mean, they would not do all this, review all these cases if they were not convinced to go before the United Section. So we expect the United Section to have a hearing, most probably across the new year, so December, January, around maybe before the Constitutional Court spring decision, and most probably going to revert. I mean, I cannot see any different approach, because normally you go before the United Sections if you have a contrast in the presidents. But here we have only 2 presidents, the one in 2023, the 17161, and the other one in 2024. So with 2 presidents which are on the same line, on the same side, there's no contrasting president. So they wouldn't do all this work without any opposite president if they were not going to change this the approach. So that's my guess, that's my best guess. Again, decision is upon the court. When we hear the United Section make a decision, we will know for sure that the minor case has changed, approach has changed. Because so far to date, most of courts are rejected. Palermo, Bari, I mean, all those courts who were favorable to president are rejecting. There are few, which I'm not going to mention, but very few, a couple maybe, which still are, I'm not going to mention, I don't know, it's Napoli, and court where Catanzaro, Campobasso, I believe there's another one, where the courts are, there's no really contrast, but there's no one bringing forward the president from the Constitution, from the Court of Cassation, the two that I just mentioned, and the judge, they have no argue on this matter, and so they just move forward. But I must mention a sentence by a judge in Turin, Judge Natale, who specifically said, I know there's a precedent by the Court of Cassation which rejects the minor case. Nevertheless, and he mentions the case, the number of the case number, but he says, nonetheless, I do not agree. And I believe that Article 7 is a special provision, and Article 12 is a general provision. So Article 7 prevails on Article 12, also because the petitioner are from US and they got birthplace citizenship. So parents, when they naturalize, cannot pass on the children the US citizen because they already have it. So I do not agree. He made a reason for that. He wrote a reason for that and approved the case. So that was really interesting, and an interesting approach.
So when we're looking at Article 7 versus Article 12 in this argument, when we have, say, an Italian-born child immigrates with their Italian-born parents, and those Italian-born parents naturalize while the child is still a minor, let's say in the United States, that Italian child is pretty much always been considered to have lost their Italian citizenship at the time that their Italian parents naturalized. Now, it was meant to apply to those children born in Italy who would lose their Italian citizenship because they had no other citizenship that was gained at the time of birth. Whereas those children born in the United States, in that same scenario where their parent naturalizes while that child is a minor, they have been treated differently under the law up until these recent changes because they were born in a country where they obtained citizenship at birth by the nature of being born in that country, like in the United States, being a jus solis nation where the law of soil prevails.
That's why we should adopt Article 7 in those cases where a child was born in the US. So we must be referring to all those cases where the immigrant went to the US, had a child in the US, and after naturalized. After the child was born, she naturalized. And that's, that in that case, we should apply Article 7. The child is saved. He retained his Italian citizenship just the way he has been for over 150 years.
Thank you for explaining that. Now, do you have any gut feeling on how this United Sessions of the Supreme Court is going to go? How do you think this is going to turn out? Where do you think they're leaning?
It's a gut feeling, because you can never predict the court's directions, avenue they might take. But again, considering on all the Court of Cassation making all these changes in putting back on the docket a case that was already decided theoretically, because at the court, the hearing in January 10th was already held. So they put the case back on the docket. They had 3 cases heard in April 1st and 2 cases heard in May. And then they made without any opposite precedent. There's no opposite precedent by the Court of Cassation, which is the standard when you defer cases to the United Section, is to make precedent, to put the precedent together and say, this is the new way you should take it for the future. And without all of this, they send everything to the president of the first section in order for her to send it to the United Section. I believe they're doing all of this because they're going to change the approach. That's my feeling.
Yeah, so I want to talk a little bit about 1948 cases. A lot of people felt like the need for 1948 cases might disappear under the decree law and the subsequently converted law. Obviously, my work with you and some of our clients that we've been working on together, there's lots of people still looking to file 1948 cases. Seems like there's still lots of need for that. We haven't really seen 1948 cases make it all the way through the process yet since the new law went into effect. What do you think about all of that related
Well, the
to
destiny
cases?
of our 1948 cases is pretty much connected to the destiny of all cases that would be decided according to the Turin case, because the Turin case would say that everyone born before that date would be managed in the same way, and that precedent it's a strong precedent. It's just not a it's based, first of all, holds. It's not a standard precedent like you do in from the Court of Cassazione, standardly based on upon judge of merit or Cassation interpretation of the law, because behind that case there's a constitutional court decision. Is the decision that the two decisions, actually, the one from 1975 about equality of gender, because the woman who marries a foreigner cannot lose her citizenship without deciding to do so. So it can be automatic. That was the 1975, which changed the Law 555, Article 10, Provision 2. And the other one is from 1983 that sets the equality of, again, of a gender of a parent within the family, because of Constitution saying so, saying that a child is able to derive citizenship from a mother. Why not? So it's based on the constitutionality of a law. So it's a very strong precedent. What happened in 2009 with the Cassazione was to extend that case backwards till after 1940, even before 1948. And I don't think this is going to change between judges. First of all, because the more we go in the future, the more the constitutional principle expands, become more integrated about human rights principle, equality of gender, equality among races. So it's expanding. Reading the decision from 2009, the judges specifically say that no matter that the woman is deceased, that the person is deceased, or the people along the line is deceased, today the person requesting citizenship should still be enabled to ask it anytime. And now that let me thinking about this, there's a passage in decision 142 that refers to 2009 decision and says that citizenship can be brought to court anytime, and no matter what, that strengthens that kind of concept of citizenship be challenged at any time. So no matter when it happened, deprivation happened. So because of this, I don't think the 1948 case is going to change. Of course, who are you going to apply? There are very few cases now with two generations. So if the generational limits will be maintained for the future generation, it will disappear in the long term, because how many people you can find that would be second generation? The parent will have been born before 1948, because in order to apply that, you need, it would be less and less.
Unless the applicant is up there in years, they probably aren't going to have somebody who fits the parent-grandparent two-generational limit.
Yes. But the vast majority will be reintroduced when the Constitutional Court would say, hey, we can't deprive people that are already born before March 28. So all those people with a long lineage, they will still apply. So I believe that the 1948 case is going to work for at least, for a long time, stay for a long time.
Wow. So I hope you enjoyed part 2 of my interview with Mr. Grasso. Now, as I pointed out in part 1, everything I have heard him predict or suggest will likely happen has come true so far. And to hear him say that he believes the new law may ultimately only apply to those born from March 28th onward, and then he believes the Italian Supreme Court may very well reverse the minor issue ruling, blocking so many people over the past year, is certainly great to hear and provides a lot to be hopeful for in the coming months. Now be sure to like and subscribe to make sure that you get notified when the third part of this interview is released. And as I mentioned before, Mr. Grasso, like many of the top Italian attorneys, have been recommending that people who are blocked by the current restrictions in place, but who do want to take advantage of the possible changes in the eligibility restrictions moving forward, are going to want to start gathering all of the required records and documents as soon as possible. These documents can take 6 or 12 months or more to gather in many cases. So those who start now will be ready to make their move when these favorable court decisions come down, which could trigger an avalanche of court cases and applications from the many thousands of people around the world who are sitting back, watching and waiting to see what happens in the Italian courts over the next few months. Now, if you'd like to understand your eligibility and get started collecting the required records and documents to apply or file for recognition of your Italian citizenship, I do offer affordable 20, 30, and 60-minute consultations where I can help you get clear on how to move quickly and efficiently toward having your case ready to go when the time is right. You can book your one-on-one consultation with me on my website at italiandual.com. I look forward to speaking with you, and I'll see you in the next video.